Our top story this evening. Delhi's Deputy Chief Minister Manish Sisodia will continue to be in jail for another week. The Supreme Court has adjourned the hearing in his bail plea till October 12th, but the top court had some pretty tough questions for the ED and the CBI. To begin with, the court asked agencies about where the proof was against Mr. Sisodia. The court said that agencies have talked about a 100 crore scam and a 30 crore scam. Both the ED and the CBI have given different figures. But where is this money? Where are the proceeds of the crime? These are the questions that the Supreme Court today has posed both to the ED and the CBI, which are probing different cases against Manish Sisodia in what we now call Liquorgate. When the Additional Solicitor General, arguing on behalf of agencies, brought up the statement of approver Dinesh Arora as proof, the Supreme Court wasn't too impressed. The court said that the case against Manish Sisodia seemed to be based on inferences, and in cross-examination, it will fall flat in 2 minutes. Before I go to my guests, let me go across to my colleague Bhavtosh, who's been tracking the story for us. Bhavtosh, you've heard what the Supreme Court has had to say to the ED and to the CBI. Does the ED and the CBI have any answers to the tough questions that the Supreme Court is probing? The crux of the question is, show us the money. Where is the money trail? You are saying this is a scam worth 30 crore rupees or 100 crore rupees. Where is the money?
Well, Shreya, that's a question that has been repeatedly asked by the Aam Aadmi Party and also by several opposition parties. The fact remains that both ED as well as CBI have remained adamant that there is an alleged corruption in the then excise policy 2020-2021, with even ED saying that if there is no corruption, why was that excise policy recalled? As far as ED is concerned, some very tough questions were asked by the division bench, and the questions were asked by Justice Khanna, that where is corruption, where is the money trail. In fact, right from the time when Mr. Sisodia had filed this bail application, Supreme Court had said that they want to understand what is the alleged proceeds of crime. Having said that, ED also had approached the lower court seeking custody of Sanjay Singh. There also, one question that was asked by special judge was why they did not ask for summons for Sanjay Singh earlier.
That's true. We'll leave it there for the moment, Bhavtosh. Thank you very much. The Supreme Court asking some tough questions of the ED and the CBI. Let me go across to our guest this evening. Amit Tiwari is spokesperson of the BJP. Joining us on the broadcast, Ravi Srivastava is a political analyst, and Aditya Pratap is an advocate. Let me first come to the BJP. Amit Tiwari, what the Supreme Court today has asked the ED and the CBI is exactly what the Aam Aadmi Party has been asking for the last 8 months, ever since Mr. Sisodia was sent to jail. You are saying there is a scam, but where is the money trail? Paise kahan hai? If money exchanged hands, where is this money? And in 8 months, you have not been able to find this money, then there is something, there is a question of competence on the ED and the CBI.
No, ma'am, I'll answer. First of all, please remember one thing, that this is an adjudicatory process. Whenever any bail application is listed, obviously there are certain relevant questions which the court, which is an independent authority under the Constitution, will definitely ask some questions. These questions are generally as to what is the nature of the offense, what is the role played by the applicant, what is the money that he has received, what is his contribution in the commission of the crime. So now hearing has not concluded. Obviously, Supreme Court, well within its power, has posed certain questions. The learned ASG is answering them. His submissions have not yet concluded. He has said that another 30 to 45 minutes. But let me point out, if you go through the order of the Honorable High Court, which dismisses the bail application of Manish Sisodia, his role is very categorically mentioned. That on 15th of March 2021, when the policy was being formulated, there was a draft cabinet note, draft policy in his computer, which recorded 5% commission to the wholesalers. Now, on 19th of March 2021, this 5% increased to 12% without there being any communication or discussion with the group of ministers. On 20th of March 2021, and all these facts are recorded in the judgment of the Honorable High Court. On 20th of March, Buchi Babu's phone had the draft policy and the group of ministers report, even before the same was placed before the cabinet. Now, this was in the computer of Mr. Manish Sisodia. How did it come out? Has Mr. Manish Sisodia ever stated or ever preferred a complaint that somebody in his office leaked the report? No. And during that time only, from 14th of March to 17th of March 2021, the South Lobby representatives were sitting in Delhi in hotel where meetings were held. So this clearly demonstrates his role. Now, coming to the question that you have posed, obviously, Supreme Court has today pointed out certain queries. They have also asked as to what are the money trails that you are alleging, because Dinesh Arora, as per his statement under Section 50 of the PMLA Act, has categorically said that through Vijay Nair, entire deal was stuck. 100 crore was taken as kickback, 6% kickback, because the commission was increased from 5% to 12%. So 6% kickback was used. And as per the prosecution story, this money was used in Goa election. Now, in all these cases, money trail is very difficult to point out because these are not rooted through financial routes. They are always rooted through Hawala in cash. And those monies are utilized in the election processes. Obviously, they are difficult to trail. But let the learned
so today the court has also said that. The court has accepted that in a case like this, it is difficult to establish a money trail, but the court is also going on to tell the ED and the CBI that this is where your competence comes in. Again, I say, it was in February, late February, that Manish Sisodia was put behind bars. From late February to early October, the CBI and the ED's combined strength and combined might and combined influence has not been able to trace even a single penny. So then there is a question on their competence. But let me quickly get in Ravi Srivastava, who will be... Ek minute. Ravi Srivastava, you're speaking on behalf of the Aam Aadmi Party. Fact is... Ek minute. Ravi Srivastava, fact is that the Supreme Court can ask as many tough questions as it wants to of the CBI and the ED. But the fact is that at the end of the day today, Manish Sisodia has still not got bail. He will still continue to be in jail for another week.
I fully agree with you. I fully agree with you. Observations, comments, this kind of questions, they are the routine process in the court. But this process shows that where the court is inclined to. Correct. I don't know whether he'll be granted bail or not.
Evidence should have come forth by now.
Can I'm hearing sounds, please. Yeah. So it is whether the court
even I'm hearing sounds. Give me a minute, Ravi Srivastava is speaking, so let him complete, please, everyone.
Yeah. So the court, whatever it does on 12th of October, it is court's prerogative whether they grant the bail or not. But either today it recalls me a film, English film, which I saw many years back. Show me the money, honey. Where is the cash? Where is the money trail? Who got the money? Even if you read the observations carefully, in one line, in para, they have said, somebody gave money to somebody, somebody used it somewhere for some purpose, but somewhere, who is the somewhere, who is the someone, who is the somebody? Now they are relying, there is a deal. The deal is with YRCP government. The YRCP MP son is involved in this, that Muganati or some name, I don't exactly recall. That person was in jail 2 years before. His name is Raghav. 2 months before, he was given a bail. And today he has been made, 3rd of October, he was made the approver. He along with Dinesh Arora. And both on their statements, ED made a raid on 4th of October and arrest Mr. Sanjay Singh. Now, here is the case. This person, Dinesh Arora, himself was an accused. He was in custody for more than 1 year. What kind of tortures he has gone through? What kind of, arm twisting has been done to him? You don't know. I don't know. So why he changed? And he has changed his statement not once, several times. So the court observation on this, the arguments will fall flat in 2 minutes if you continue with this. Court has given another week that you go find out something.
Aditya Pratap. Okay, Aditya Pratap, the additional Solicitor General who was arguing actually the case for the CBI and the ED, brought up Dinesh Arora, right? Because Dinesh Arora is the approver in this case, and he seems to be the card that the ED and the CBI are depending on. Ki ye dekho, ye approver hai, and the approver is saying that that Sanjay Singh is involved. The approver is saying that Manish Sisodiya is involved, right? So everything, a
Yes.
large part of the case is based on what this approver is saying. But the fact is, we all need to remember that the approver is an approver to the government, essentially to argue that the approver has turned approver and is essentially now batting for the other side, right? That is what we
Yes.
that's how we should understand it. The Supreme Court today is
Yes.
saying your entire case seems to be based on inferences, and if there is a cross-examination of what Dinesh Arora is saying, your case will fall flat in 2 minutes.
Very true. See, because in a criminal case, the essence is that the prosecution has to prove the case beyond reasonable doubt. Now, let's suppose Dinesh Arora turns an approver. Obviously, the prosecution might bat for leniency or a lesser sentence or plea bargaining for him. But the point is, can Manish Sisodia be convicted solely on account of the testimony of an approver? Absolutely not. First and foremost, the approver has to be cross-examined. Secondly, something has to come forth, which is what the Honorable Supreme Court said, is that you all are conducting the investigation. Did you come across something concrete? Did you find any money trail connecting Manish Sisodia with the concerned person who's giving the bribe? Then Dinesh Arora. And then if you see the ingredients of Section 7 of the Prevention of Corruption Act, Section 8 of the Prevention of Corruption Act, is there any demand? Is there any payment of money pursuant to the demand? We have case laws like Zubair versus State of Kerala, where you have to give proof. And let me give my independent perspective also here. The government today, if Mr. Manish Sisodia gets bail, it is likely that the government will fall victim to a statute of its own doing. 2018 government amended Prevention of Corruption Act, and a potent section, which is Section 13(1)(d), which could have probably, heavily caused problems for Manish Sisodia, that was done away with, obviously to favor. I mean, we all know, because 13(1)(d) was the #1 section used to target corruption at high places. So obviously now when the government is lying on Section 7, Section 8 and other sections, they actually have to show that there was a demand of money, that there was a payment of money. And that is where the Supreme Court is now saying that where is your proof, where is your evidence? He's been behind bars for months. And best of all, let me tell you, when Section 13(1)(d) was there, all you had to show was this public servant conferred a pecuniary advantage by corrupt and illegal means. So, but the government, for its own interest, did away with this provision in 2018. And now, clearly, I mean, the government has...
No, but the provision was draconian. Whether it is applicable to the government or the opposition, the fact is that that provision of the PMLA Act was draconian. And it needs to go.
No,
otherwise, you can implicate absolutely anyone you want to, including a mango tree. Right?
No, the point is...
Amit Tiwari, that is the accusation. Go ahead.
Yes. Yeah, because Section 13 was I don't want to digress from the topic, but what I'm saying is that given the current framework of the Prevention of Corruption Act, where the Act insists for, a concrete demand, a proof of payment of money, show the money link, the money transaction, clearly, in my opinion, the testimony of an approver is solely on its own accord. It's a settled law, a mere approver's testimony without something concrete coming to light, like a documentary evidence or money trail, it is not sufficient to convict Mr. Manish Sisodia. And because ultimately they have made policy. Now you have to show that
a lot is being said.
Amit Tiwari, then for the ED and the CBI to say that here is Dinesh Arora, here is the businessman, close aide of Manish Sisodiya, someone who was introduced to Sisodiya by Sanjay Singh. He has said that Sanjay Singh is involved. He has said that Manish Sisodiya is involved, which is why we want to continue to keep them in jail. That simply won't hold, which is why the Supreme Court is asking these tough questions. In fact, at one point of time, Amit Tiwari, the Supreme Court also says it doesn't seem that Manish Sisodiya was involved. Now, I agree these are oral observations. I just want to tell our viewers there is no ruling in the case. The bail hearing has been postponed to October 12th.
Yes, that's right.
But at one point of time, again I'm saying, Amit Tiwari, the Supreme Court is also saying that it seems that Manish Sisodiya was not involved. If on 12th of October he is given bail, will it be a big slap on the face of the ED and the CBI or not?
No. I am nobody to predict as to what will be the judgment of the Supreme Court. But let me clarify one thing, and my friend Aditya will also endorse this. So far as the issue of approver is concerned, please remember that the procedure is established by the law, that when somebody is proposed by agency to be an approver, his statement under 164 is recorded by a judicial magistrate who is a judicial officer. His statement is then placed before the court of the competent jurisdiction, which accepts and may not accept, because it has to be adjudicated whether he has disclosed complete and full truth or not. So today, the proposal that Dinesh Arora wants to become the approver and wants to point out as to how the entire offense took place, his proposal has been endorsed, accepted by a court, the same court which we are talking about today. So therefore, the testimony of approver, though it requires corroboration, and if we see from the all facts, as I pointed out from 15th of March to 20th of March, how the policy was changed single-handedly by Mr. Manish Sisodia. Obviously, when you have a conspiracies like this, which are hashed in deep secrecy, obviously some approver will have to throw a light on it. And then coupled with the other facts, an inference is drawn whether the accused is guilty or not. Now, the second question that you are talking about is
but
that
Amit
Manish
Tiwari,
Sisodia is not...
you turn approver.
Sorry?
Amit Tiwari, for example,
I'm sorry?
you turn approver in a case, you tell agencies all sorts of things, or I turn approver in a case and I tell agencies all sorts of things.
Yes.
I need to prove them also, na?
Yes, but when...
In this case, I need to establish a money trail. Again, I am saying the investigations into Liquorgate have been going on for how long? Alleged Liquorgate have been going on for how long? In 2 years, the ED and the CBI have not been able to pick up anything.
Money trail and...
8 months Manish Sisodia has been in jail. You have not been able to pick up anything.
Ma'am, let me now answer to this. Being an approver and money trail are two different issues. The fact that you were pointing out that yes, Dinesh Arora has turned approver, his testimony is recorded, his testimony will be used, he will be cross-examined. Now the question that you are posing it, has it been proved? The question of proof will come after the trial and not today as on the bail. And his statement under section 164 recorded will have a evidentiary value. Now the second question that you were initially posing, that the court has said that it will fall apart in 2 minutes during the cross-examination. This was not the observation of the court in view of the fact of being Dinesh Arora approver, but on the issue of hearsay, that if some evidence is hearsay, obviously it will fall flat. But the Dinesh Arora's evidence or the testimony, coupled with the fact that what the role Manish Sisodia has played, it will stand during the trial. So now let us not predict anything. The arguments of the learned
Aditya Pratap is an advocate. You're contradicting me here.
Yes, certainly. Yes.
You know, Amit, I'm not a lawyer, but you have contradicted me and I'm very happy to be corrected. But let me just get the advocate on the show into this matter. Aditya Pratap, sure, when the court made the statement about the fact that your case will fall flat in 2 minutes when there is a cross-examination, was it referring to the approver or not? Please help us understand that.
No, absolutely. Because see,
100%.
The concept, absolutely, because the system of approval is effectively governed by section 306 of the Code of Criminal Procedure, where the magistrate, where the concerned court has the power to tender a pardon, has the power to tender a pardon to an accused or maybe a reduced sentence in exchange for making a full and true disclosure of the whole of the circumstances within his knowledge relative to the offense and to every other person concerned, whether as a principal or abettor in the commission thereof. Now, the issue which has arisen here is that, and of course, then the magistrate there's a full requirements that every person accepting a tender of pardon shall be examined as a witness in the court of the magistrate taking cognizance of the offense and in the subsequent trial and so on. So what it essentially says is that the person whom turns an approver, he should first give the full disclosure of his role in the crime and everything.